Hello, I'm attorney Jonathan Blecher. I'm a criminal defense attorney with a practice primarily confined to the defense of driving under the influence cases. I want to talk to you a little bit today about the Florida implied consent warnings. Whenever an individual applies for a Florida driver's license, they must sign a statement on their driver's license, and you can look at it on the bottom of yours, that says that you agree to any breath test or test for sobriety required by Florida law. Well, that's a very narrow statement, and there are a lot of permutations that go along with that. In order for an officer to request a breath, blood, or urine test from you, several things have to occur. The officer first must have probable cause to believe that you are driving under the influence of alcohol and/or a controlled substance in order for a request to be made for a breath test. In the event that an individual declines to take a breath test, the officer must read the driver the Florida implied consent warnings. Despite the fact that an individual has already consented, an individual must be advised of the Florida implied consent warnings before any administrative action can be taken on their driver's license. So, when an individual is arrested and they allegedly refuse to submit to a breath test, the police officer must read you the following statement: that you're now under the arrest for driving under the influence of alcohol or a controlled substance. You'll be offered a breath test for determining the alcohol content of your blood and/or a urine test for the detection of a controlled substance. Should you refuse to take either of the tests, the Florida Department of Highway Safety and Motor Vehicles will suspend your driving privilege for 6 months for an unlawful blood alcohol level, or 1 year if you refuse to submit to the breath test, and 18 months if there's been a previous suspension for refusal to submit to a blood, breath, or urine test. If the officer fails to read you the Florida implied consent warnings, and there is a refusal, the person has not been properly advised of their rights under the Florida implied consent law, and the attorney can file a motion in limine or a motion to suppress the evidence of the refusal to submit to the breath test. Again, if an officer doesn't have adequate probable cause to believe that an individual is under the influence of alcohol, the officer can't ask even for a blood, breath, or urine test. For more information, please contact our website, www.duilawdefense.com. I'm attorney Jonathan Blecher.